the night before publication for quote-unquote fact-checking. Those allegations are false, and the New York Times either knew they were false or acted with reckless disregard as to their falsity.
This just in, Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
Justin Baldoni's lawyer just detonated a legal bombshell on Blake Lively and her cheerleaders at the New York Times, flipping the entire lawsuit upside down.
The text messages and other documents that we've obtained reveal what really happened.
Turns out money and fame don't make you invincible, especially when you've got a courtroom tactician like Brian Friedman on your side.
Or media outlet by suing them for defamation or libel.
With the latest jaw-dropping details he's revealed, it's becoming painfully clear who's actually winning this battle.
Wrongly casting them as villains and making them scapegoats for Lively's well-publicized media misstep.
At the center of this firestorm is the New York Times, whose slanted coverage of the Baldoni-Lively lawsuit painted him as the villain in a supposed smear campaign to annihilate her reputation.
The New York Times published a story titled, "We Can Bury Anyone Inside a Hollywood Smear Machine."
From the start, the Times framed Baldoni in the harshest light, leaving no room for nuance, treating Lively's allegations not as accusations, but as unquestionable truths.
Wayfair parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film.
Their articles and videos went further, pushing the idea that Baldoni and his Wayfarer colleagues masterminded a grand conspiracy against Lively, crossing the line from journalism into outright defamation.
The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfarer parties and falsely accused them of having waged a smear campaign.
But once the lawsuit gained traction, the Times started to panic. They realized if Baldoni didn't come after them, Friedman certainly would. That was the breaking point.
Admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
Scrambling, the Times tried to quietly backpedal from its own reporting. But by then, the damage was irreversible, its credibility already hanging by a thread.
He's saying, hey, it just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond. We scrambled, and you still published it before we could even get our response to you.
Friedman wasted no time in exposing these blunders, making it clear the Times didn't just report recklessly, it actively joined the defamation campaign. By presenting Lively's story as fact, the paper acted with malice, knowingly publishing falsehoods in the most destructive way possible.
Times prepared its salacious article well before TUI contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times months of plotting with the Lively parties, the Wayfair parties got hours to respond.
This wasn't sloppy journalism. It was calculated manipulation. By openly endorsing Lively's version of events, the New York Times created the illusion that her claims had been independently verified. In truth, much of what they published couldn't withstand even the lightest legal scrutiny. This wasn't reporting. It was narrative engineering.
The New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfair parties to specify the acts taken by the New York Times in connection with its scheme with the Lively parties.
Now the fight shifts to the courtroom, with Brian Friedman leading the charge against the Times' desperate attempt to shut the case down. The paper filed a motion to dismiss, hoping to kill the lawsuit before it could gain traction. But Friedman fired back with a devastating counterargument. The Times had forfeited its most crucial defense, the fair report privilege.
Jury will determine the truth based on the evidence, but the Wayfair party's allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfair parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California.
That privilege exists to shield media outlets when they're merely reporting on matters of public concern. But as Friedman points out, the Times didn't merely report. They went a step further, treating Lively's accusations as proven fact, as if their own investigation had substantiated them.
New York-based New York Times insists it is entitled to New York law no matter where their harm was felt. But California law remedies harms suffered in California by California residents.
Friedman's central argument is simple. The fair report privilege collapses the moment a news outlet stops reporting and starts advocating. By framing Lively's allegations as verified truths, the Times crossed that line. And in doing so, they didn't just make a mistake, they committed a profound breach of journalistic ethics.
Under either California or New York law, the Wayfair parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report privilege.
His legal team is determined to hold the Times accountable, arguing that when a media giant has the power to sway public opinion, it also bears the responsibility to tell the truth, especially when reputations, livelihoods, and careers are hanging in the balance.
Argue your defamatory statements affect my client specifically in California. And this modern world we live in with the internet really makes it that you're damaged no matter where the defamation takes place.
Meanwhile, the Wayfarer camp, including Baldoni, has taken a bold strategic step, pushing for California law to govern the case instead of New York law. Their reasoning is clear. The damage to their reputations, their livelihoods, and Baldoni himself occurred in California. And if the court agrees, the legal landscape could tilt heavily in their favor.
The New York Times has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department.
California law, far more protective of individual rights in defamation and false light cases, stands in stark contrast to New York's stricter framework. Unlike New York, California gives public figures like Baldoni broader tools to fight back against damaging falsehoods.
Actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability.
The differences don't stop there. California law makes it easier for plaintiffs to recover damages for emotional distress in defamation cases, something notoriously difficult under New York law. That distinction could translate into significant financial remedies for Baldoni's tarnished reputation.
For maliciously colluding with Lively and her cohort to publish a false and defamatory hit piece about the Wayfair parties.
The differences don't stop there. California law makes it easier for plaintiffs to recover damages for emotional distress in defamation cases, something notoriously difficult under New York law. That distinction could translate into significant financial remedies for Baldoni's tarnished reputation.
FAC also states claims for false light, promissory fraud, and breach of implied in fact contract.
Put simply, California allows a plaintiff to seek damages for both reputational harm and the emotional fallout of false reporting. That dual path means Baldoni could potentially secure far more compensation if California law governs the case.
That the New York Times conspired with Lively, Reynolds, Sloan, and Vision PR to advance a false and defamatory narrative concerning the Wayfair party.
This choice of law could reshape the entire legal strategy. The Wayfarer camp has argued that the defamatory reporting by the Times inflicted its deepest wounds in California, where they live, work, and built their careers.
Allegations that certain of the Wayfair parties engaged in sexual misconduct towards Lively, and 2, allegations that the Wayfair parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation.
By applying California law, Baldoni and his team gain a stronger foundation to prove harm and pursue damages. And with California courts often favoring individuals over massive institutions, the scales could tip sharply against the Times.
The New York Times either knew they were false or acted with reckless disregard as to their falsity.
Naturally, the New York Times is fighting this tooth and nail. As a New York-based publication, its lawyers insist New York law should apply, arguing that the alleged defamation occurred at the source, through its New York newsroom. What we're left with is a high-stakes legal tug-of-war, California's individual protections versus New York's institutional shield.
Again, this is one of the problems that does exist when it comes to news organizations, is you want them to be protected so they can't just have malicious people come after them if they don't like their reporting.
The outcome of this jurisdiction battle could prove pivotal. If California law applies, the risks for the New York Times skyrocket, exposing the paper to steeper financial penalties and even deeper reputational fallout.
But they got to be fair. They got to at least try to tell both sides of the story. Or do they not? We'll find out.
But if New York law prevails, Baldoni and his team face an uphill climb. New York's framework is far less forgiving to individuals claiming defamation. That's why Brian Friedman has shifted the focus to another cornerstone of the case: actual malice. For public figures like Baldoni, proving malice isn't optional, it's everything.
Better for them to double down on their beliefs that they did the right thing versus admit defeat.
The actual malice standard demands proof that the defendant knowingly published falsehoods or acted with reckless disregard for the truth. Friedman argues the Times did exactly that, publishing Lively's claims while either knowing they were false or deliberately choosing not to find out.
For example, in both the article and video, the New York Times presented as unquestioned fact the false and defamatory claim that the Wayfair parties orchestrated a smear campaign, citing to thousands of pages of documents it had reviewed and claims that the text messages show that the Wayfair parties had engaged in the wrongdoing of which Lively accused them.
According to Friedman, the Times had access to documents and communications that directly contradicted Lively's story, yet chose to ignore them. Instead, they printed a one-sided narrative that painted Baldoni as the villain. This wasn't reporting. It was a calculated hit piece. By elevating Lively's false narrative while suppressing the facts, Friedman insists the New York Times acted with actual malice.
What they're arguing here is not everything that was in the New York Times made its way to the complaint. And I guess you would look at that and say, well, maybe Lively and her lawyers wanted to include more that wouldn't have to stand up to rigorous defense in the legal system.
The Times' failure to properly vet Lively's claims and its decision to ignore contradictory evidence bolsters the case for actual malice. Friedman's team points out that the paper had access to private communications between Lively, Baldoni, and others that directly undermined her allegations. Yet instead of weighing that evidence, the Times pressed ahead with an article and video that cast Baldoni in the worst possible light.
Black's Law Dictionary defines the phrase smear campaign as the deliberate telling and repetition of untrue or distorted stories about a person in order to make others lose respect for that person.
Friedman goes further, underscoring the Times' reckless disregard for the truth. This wasn't just a failure to investigate thoroughly, it was an active distortion. The newspaper manipulated the information it had, shaping it to fit Lively's narrative rather than presenting the full picture.